I'm seeing you.
And it's a pretty sight, ain't it? How are you?
Hi, I can hear you too.
Ta-da!
And oh, look at your background
Well, yeah.
on you.
I
How
don't have,
bad is mine?
I,
Does that pile of newspapers really ruin the effect, or does it make me look like a busy lawyer?
I don't have a pretty office in the Golden Tower like you do. So
Well, you have multiples.
that's right. Actually, I do. I got more offices than I know what to do. You know,
How
so
are you?
I'm great. I'm excited. Let's
Me
do
too.
stuff. Let's play.
We had a large group of people sign up. So,
Oh, really? How many are we going to have on, you think?
well, we had 17 sign up. The hard thing is a lot of them know because I started this at the pandemic, right?
Mhm.
So a lot of them know that if they sign up,
They get a recording later.
they get a recording later.
Yeah.
So they'll not attend. But I suspect I looked at the list and I recognized a good number of people. Adam Robinson is one of them. Tim Raines, another that I remember just off the top of my head of as people I recognized. And those guys do uh, tend to actually show up. So
Yeah.
hopefully, I just think, Mark, that you have so much information to offer that if somebody has a burning question, I'll let them put it on the Q&A or the
Hmm.
chat. But I think what I'll ask them to do is submit it for later.
Okay.
Um,
Well,
and
that'll kind of keep some continuity because
right,
otherwise we can go several directions with all of.
right. And I'm worried that with this subject. Well, I've got this one employee, or I've got there's
Exactly. Well, I know you would get that from one of the people you mentioned because candidly, they want me
okay,
to help them with stuff. So,
okay, good, okay.
yeah.
One out of two, one out of the two of them is your client. Actually, I should tell you, I happen to know
No, two out of two are my clients, but
two for two. I sit on a CEO roundtable through Jim Moran Institute with Tim,
mhm.
and he was saying good things about you just yesterday. So I hadn't actually thought about that yet this morning. But as soon as he said you were helping him with the arrangements in the for India,
Mhm.
uh, the contracts, I was like, "Oh wow, you got good counsel, man. That's great." So,
Well,
uh,
thank you. I don't know about all that. I hope I don't
uh,
mess it up too much, but
mhm.
the timing on all this stuff's kind of important because you write a contract for these guys and then have the law change right after you write it with
Right.
a lot of the turbulence in this particular area. So,
Does that
I've strategically gone, I need to slow down a little and like
ah
roll this out because I'm going to roll it out. And then next week we're going to have, maybe more guidance with regards to what should be considered in some particular aspect of a contract. So,
fascinating?
yeah,
Wow. Do you do a lot of international practice?
no.
I mean,
I
either.
do a pretty good amount because I office with Francis Boyer. He's an international lawyer.
I forgot that Francis was in with you. Of course, I know Francis.
Yeah, and we collaborate on cases. Mostly him doing litigation work for me, not me
Okay,
international law, but he's pretty much learned litigation through collaborating with me.
got it.
Before that, he was pretty much transactional, almost exclusively. He wasn't a person that dealt a lot with the courtroom. Now I think he's predominantly litigation now.
Is
So
that right?
yeah,
I'll
but
try to
I
move so I
don't
get
go
that.
in there very often now because I'm shifting my focus and basically taking select clients and not that's not my focus. I mean, I'm teaching 400 students and I got JVP working on top of the law firm. And I also have
Hey, Mark, let me welcome Heather. Hi, Heather. You're the first one to jump on with us this morning. Way to be early. We'll give folks about 5 more minutes to get on. I guess since Heather's on, I could play our theme music, though. I like to get the Commodores in whenever I can. I'm sorry, Mark. You were saying something way more interesting than me.
I don't know. More interested in the Commodores? Are you sure?
All right, tell me your favorite Commodore song.
Oh goodness. I don't know. I like the once, twice, three times a lady.
Oh, that's a good one. I love Easy Like Sunday Morning, man.
Easy. Yeah, that's
Yeah.
a good one too.
Then I was a funk guy when I was coming up, so I liked all that really
Yeah.
funky stuff with the horns they used to do.
Lionel Richie was a fan of mine. I was a fan of his. Yeah,
Yeah,
he was a favorite.
absolutely. Well, you're listening to him right now from 1977, the Commodores, Zoom. We all should have taken their advice and bought Zoom stock about 5 years ago.
Wouldn't that have been nice?
Probably wouldn't be here today and needing to work. um, I don't know if you know, I talk about it occasionally on these webinars. The first place I remember, now I was born in Richmond, Virginia, but dad's first job was in Tuskegee, Alabama. And so the town square has been renamed for many years now, Commodore Square, after the most famous
Right.
of former students of Tuskegee University, because I would not put them up against some of the former professors of Tuskegee University. I believe that would be Booker T. Washington and George Washington Carver, if I'm correct. Uh,
Wow.
you will find this interesting. Uh, my parents were friends of Dr. Gomillion. Dr. Gomillion was president of then Tuskegee Institute when they were there, and he is the one who was the plaintiff in the gerrymandering case, which Fred Gray, and of course, Fred was the attorney for the Montgomery bus boycott, Martin Luther King Jr. and Rosa Parks, that Fred Gray took all the way to and won at the United States Supreme Court on gerrymandering. Uh,
Wow. How cool is that?
called a 57-sided dragon. They literally had drawn the voting districts. Good morning, Heather. I see I got two Heathers and an Adam. Good morning, guys. Glad you're here. We're just chatting for a couple of minutes, giving people probably 3 more minutes to jump on, and we are listening to the Commodores, of course, because we are on Zoom. Anyway, they had drawn, literally they went down streets and drew the city voting districts so that they could assure themselves of basically white people voting and succeeding. And of course, the U.S. Supreme Court in the 50s, or I guess it might have been 60s, I'd have to look that up, threw that out. So Dr. Gomillion was a real hero in his time and a friend of my parents. Oh, goodness. I just pressed the pause button, guys. I'm sorry. I took Lionel Richie out of your lives for a moment there. All right. We're down to 2 minutes. Thanks for those of you who jumped on early. I see somebody else just joined, and we appreciate it. We have a lot of people signed up this morning, so I'm just going to give another minute and a half to jump on board because we are going to have a rapid run through some fascinating information this morning.
I hope so. I hope you enjoy it. I hope you find it valuable more than anything else.
Anyway, I did get to meet Fred Gray one day, which was a great moment in my life to meet a true American hero, you know. I mean, good grief.
Well,
It's a funny story he told me. Now that she's passed, he let the story out that he and Rosa Parks actually had planned the event that it would happen, uh, and
the bus seat event.
the bus seat event.
Yeah.
But she didn't tell him the day he was going to do it. He was out of town. He was the only African American attorney in Montgomery, Alabama, and she was going to stay in jail till he got back. So he said, I had to hot foot it back to Montgomery.
Determined woman. A determined woman.
Don't make the history books.
It's kind of neat when you're close to things that later amplified become so significant in our history. And
absolutely,
you know, sort of feel like you're kind of the fabric of some of that because you've been acclimated to a lot of the people and the personalities. It's not just a name to you. You can relate to those circumstances and the actual environment, which, you know, I was in Texas, and, you know, when I was growing up was when, you know, desegregation was starting, and in school busing and those types of things. And there was a lot of strife. There was a lot of challenges on all sorts of levels. And, you know, people didn't want to be where they were being sent, and people wanted to be where they are used to. And
Yeah,
so a lot of things that I experienced just as a kid in that environment, trying to figure out which way's up in the world, and really the world not having any good answers because they were trying to figure it out too. So you're
absolutely.
even closer to something historic like that. I just think that's cool.
And I'm grateful. I'm also grateful that I was too young to know how close I was to getting dead.
Hmm. Yeah.
As I look at it in hindsight and revere my father's career. I was in Florida when desegregation occurred, and have stories there too. And for those of you that think that you've joined the wrong webinar, you haven't. Mark and I, in addition to being colleagues, are dear friends, and we were killing some time and got on an interesting subject. And I see it's time to get started. So we are already recorded. I'm sure you got a note about that. I appreciate all of you joining. Really, really excited about the program we have for you. Real quick, Happy New Year. We have been doing these webinars here at Rock Solid Law and Title since the pandemic hit, and appreciate you guys' interest. I think today is going to be an amazing subject. For any of you that I don't know, I am John Miller. I'm the founder, owner, and senior attorney at Rock Solid Law and Title. And we love to provide estate planning, business law, and real estate closing services to our clients. I am so thrilled today that my dear friend, colleague, referral partner, and many other levels of relationship, Mark Addington, has agreed to join us today. We don't have time to get into the subject matter. If I told you all of the wonderful things I know about Mark and all of his accolades, but I will say to you that I refer clients to him with absolute ease of mind and knowing that they will be taken care of, that he is one of the foremost experts that I know in all things law pertaining to employment. He is also a professor at the University of North Florida. And more than that, a fun guy and a really good guy to get to know. Any of you that don't know him, I highly recommend it. Mark, welcome.
Thank you. Thank you so much. I'm glad to be here.
You're really, really welcome, my friend. So, guys, we wanted to talk today about non-compete, non-disclosure, and essentially how to separate from employment with somebody. We've got a lot of material, so I'm going to encourage everyone that if you have questions, to submit them to us at questions@rocksolidlaw.com, and we'll follow up with those. If you've got a burning question, I see Q&A has already been open. Put it down there at the bottom. I'll review it. If we've got time at the end, we'll hit it. But what piqued my interest in doing this session with Mark is an inquiry that I had several months ago, and some reading I was doing in the area of non-compete, and that it is an ever shifting, ever changing area of the law. And so I did some reading on my own. Then I had a fantastic discussion with Mark, and I asked him if he would share some of his knowledge in that regard with us. Mark, what are the current burning issues? What are the shifting sands? And with an eye toward what do business owners and managers need to keep in mind these days to retain, to protect secrets, uh, and really to reward good employees and keep others from trying to take their business secrets and compete against them in an unlawful manner?
Okay. Well, thanks for letting me talk. I'm really excited about this. And looking at all of these areas that you're describing are typically referred to as restrictive covenants of various kinds. They're like tools to accomplish certain goals contractually that a business would want, usually to protect something that's a legitimate business interest in one way or another. But before I get too deep into a toolbox, let me talk big picture. There's two sort of fundamental and competing principles. One is an employee's willingness and desire to work wherever they want to and engage in trade of their choice. And on the flip side of that coin is an employer who makes investments, who puts people in positions to gain access to trade secrets and confidential information, and has circumstances in which a employee takes advantage of that, that circumstance, such that they go off and create a competitive circumstance. And is there a way contractually for businesses to protect themselves, ironically, from their own employees to a certain extent? Most of the trade secret, confidential information is, if it's absconded from a business, it's usually done through a former employee. Not always, but often. And so, contracts are one of the tools that we might use, any of those various tools in our toolbox to prevent that. As a general proposition, the answer to whether or not a tool is enforceable or not is going to be, where are you going to try to enforce it? Because the laws that predominantly deal with non-competes and various other types of restrictive covenants are predominantly state law, and in many states, mostly common law, which means judges are making those decisions and they're found in court decisions. Not every state has a statute governing these things, but many do. So states like California or Maine, Oklahoma, ironically, take a very strong public policy stance in favor of the employee protecting their ability to engage in trade. And to various degrees, they may say non-competes are banned in my state. And then conversely, you have other states, Florida among them, that has a statute and a tradition of saying, used appropriately, non-compete agreements and those types of tools are valid contractual enforceable provisions. So in looking and thinking about that from a business perspective, if you're a small business in Florida, yes, the answer is these things are probably, if they're well crafted, going to be enforced. And I want to stress well crafted. If you're a multi-state business and you've got operations in several states, you have a patchwork of things that you need to figure out with regards to the enforceability and the strategic way in which you address it. I always like to think about business and business law, which I teach, through the lens of both compliance, but also from a strategic perspective. And what could you do as a business person strategically to protect yourself better or create a competitive advantage or whatever your particular objective is? When we think about the idea of non-competes, that's just one of the tools. I think in the title have non-disclosure. So what can I disclose to people? Having that's another wonderful toolbox. Non-solicitation, a very, very relevant tool to utilize, and not synonymous exactly with non-compete, but can frequently be used in very similar ways. The challenge is that when you have all of these variables, because states are different and state public policies are different, there's not a one-size-fits-all answer in this area of law. You have to do the analysis and think through, what are the variables that are relevant to me being able to enforce this? And the challenge is that employers historically have approached the problem a number of ways. Some employers have said, I want to craft something ironclad I know I can enforce. And so generally, when I'm crafting something like that, it would need to be narrowly tailored so that we say the restrictions are directed to legitimate business interests. That's defendable because we can show how you can be hurt if we don't enforce the agreement. But you'll have other employers that'll take a broad strategy and say, well, no, I want this to be valid for 5 years because I want it to be a detractor of people engaging in certain conduct. And while that sounds good, it's probably not enforceable. And depending on the jurisdiction, the court may or may not have the power to amend those lengths of time or that overbroadness. Instead, they'll throw the whole thing out. And so there's lots of intricacies in terms of art. In Florida, for instance, we're what lawyers refer to as a blue pencil state, which basically means that a contract can be reformed by a court. So if you were to draw an overbroad and an employer's strategy be, you know, I want to be a deterrent, so I want to make something really almost
scary,
ridiculous, then, you know, I know a court will redraw it and they'll redraw it to the most they'll give me. Not always. They don't understand your marketplace like you do. And so you're playing a risk game that they'll just throw it out. And I've seen that in litigation and in trials I've been in the past. So
Mark mentioned a well-crafted agreement, obviously. What are some of the issues for Florida business owners that you would want to be thinking about? Would a business owner want to be thinking about when they come to an attorney to talk about crafting such an agreement?
good question. Know what you're trying to protect. Don't just say generally, I want a non-compete, because we can craft to protect things that are legitimate. But just to say I want a non-compete means that we typically go to things that we default believe will probably in the context pass, depending on the situation. So it becomes riskier and there's less certainty in knowing exactly whether or not your asset that you're seeking to protect is protectable. So if you have customers, for instance, and they're specific customers, maybe a more appropriate tool for the toolbox to pull out is a non-solicitation that creates a way that you can have a confidential list of customers that's referred to within the agreement. And then that is a method of protecting those legitimate assets instead of a broader non-compete that doesn't let anyone work in that field for a geographic area for a specific time frame. So knowing what you're trying to accomplish and beginning with the end in mind, the Stephen Covey folks of the world out there, you know, knowing what you're trying to accomplish, what specific assets you're trying to protect. And then you might say, well, you know what? I want all my clients protected. Well, okay. What if the person that you're asking to sign this agreement has never had any exposure to client X? Is it going to be reasonable to believe that the court is going to keep them in a new job and a new capacity from client X when they've had no contact with you and aren't part of any sort of relationship that would be termed as a risk to your legitimate business interests? So that's why we have to kind of go through and think about what we're trying to protect, the exposure this person's had to that particular area. And it might not be a client, it might be a trade secret. Okay. Of those tools in your toolbox, one of the few of them that have a federal circumstance that addresses it is trade secrets. There's a Federal Defense Trade Secrets Act. But almost all other tools that we use contractually vary state to state, and they're state based. And the Defense of Trade Secrets Act has not been around all that long. So, you know, yeah, it's there now. Currently, there's a push to expand federal legislation regarding the tools in our toolbox. And to give you an example, last January, the Federal Trade Commission wanted to approach this problem not from the perspective of whether or not you should protect your asset, but whether or not utilizing a non-compete is an unfair method of competition in the marketplace. Okay. Well, there's substantial authority that says that that's going to probably fail. but it was proposed as a rule last January, and this April will come up for a vote. And while I personally don't think it's going to carry the day, it's part of a broader plan, I think, with our current administration to keep this topic in the forefront, because there's legislation right now to Freedom to Compete Act, I believe is what it's called, Freedom to Compete Act of 2023, to totally ban nationwide non-competes. And so do I think that legislation will go through? Not with the current composition of the various government, but ultimately it's just a campaign to a certain extent, because this is an issue that's an election issue. In addition, the National Labor Relations Board, which is the branch of government that deals with unions, there was a memo put out by their general counsel where they're seeking to put together a rule saying that it violates the National Labor Relations Act, Section 7, which basically means that you can't have unfair terms and conditions in the workplace, and unions get involved. Do I think a lot of these efforts have merit? 40, 50, 60% merit. Do I think they'll pass? No. Do I think you'll see people become more aware over time and it become a grassroots effort? Yes, on the federal side, but I think it'll struggle because we already have this patchwork that's ingrained and well established.
Mhm.
However, while all that's going on the federal side and the state side, now we have 5 states that have banned non-competes entirely. And we have several more that are trying to have it banned as well. New York passed it in their legislature, and it went up to the governor, and the governor I think it's like 2 or 3 weeks ago, vetoed it. So that's how close it got from it being banned. I mean, it being an issue for New York. And there's lots of businesses that have New York ties as well. Your question really dealt with what do employers and business people need to know. Have things well crafted, narrowly crafted to protect them. Don't be overbroad. There's an amazing case where a sandwich chain called Jimmy John's had non-compete agreements for all of its sandwich makers. What are they taking from you that's so valuable? Not a thing. But they wanted it to be a deterrent from going to their competitors across the street. And it was an attempt to keep employees. So there's things like that out there that are really sort of abusing the law because people understand it's a high degree of uncertainty in it. And if you are asking me as an employer, I would strongly encourage you to craft things appropriately, narrowly tailor them to fit your needs and the context. And I think that's the biggest piece of advice I give.
In your practice, what are the most common issues? Obviously, taking you've inferenced taking a client list and going into competition, or taking I think it's fair to say that you've inferenced processes, procedures, manners of sandwich making, but protectable ones to compete. What are some of the other issues that you most commonly find that your business owner clients are concerned with?
Well, a lot of times, for instance, if you're in a situation where you're considering a major strategic business move, it might be that you have a competitor that you might acquire, or that you have someone that you have a relationship in with an independent contractor, and you're going to want to give them exposure to things that you think give you a competitive advantage in the marketplace.
Mhm.
Those types of circumstances, things like non-disclosure agreements are certainly appropriate. And those are basically contractual limitations on the person that signs its ability to disclose information that they learn about your operation. A really interesting thing to look at is the idea of what is a legitimate business interest. Because in Florida, if it's not going to be geared towards legitimate business interests, you're probably not going to be able to enforce it. So things like those client lists are legitimate business interests. Trade secrets, confidential information are legitimate business interests. Interestingly, even specialized training. So if you have a profession or a very unique type of business where there's a process that has a very narrow number of people that understand how to accomplish that objective. Medical professionals are great examples. Not a lot of people do this particular medical procedure, and you invested the time, money, and effort to take a doctor and pay for his education in this technique. And then he's going to take the technique to a competing hospital. Well, that training and that specialized training is something that you made a significant investment and want to consider that an asset of your business because you made the investment to create that opportunity. So all of those are variables in terms of ways that we would look at which tool would be most effective in this context. And really from a business perspective, just be aware of that which is truly valuable and work hard to make sure you craft things that cover that well. Is it okay to go overbroad? Maybe, but it's not advisable. It might give you a good outcome because you get a judge that is, comfortable with how far you went. But most judges look at the statute closely. Here's another one to think about. What about, instead of your client list, what about your prospective client list? Because a prospective client list, there's less degree of certainty as to whether or not you even have a relationship to protect. So how are you going to convince a court that they should protect that prospect for you? It doesn't even have a history of doing business with you yet. And, depending on the context, there may or may not be protection for that because it may or may not be considered a legitimate business asset.
Sure.
So lots of aspects with regards to this whole area of law require a lot of individual analysis and, crafting it in a way that creates the optimum protection for the company and minimizes the risk that a judge is going to be able to throw it out. There's language in Florida statute that says that the court shall enforce, but you give enough negatives with regards to compliance to the statute, they'll go right past that shall enforce and go, you didn't follow the rules, so I don't have to enforce it. People come to me all the time and say, Mark, these things aren't really enforceable, are they? Well, you've been listening to the news, all this federal hype on what we want to do to get rid of it. Florida's been, has a long-standing history of enforcing them if they're well crafted, narrowly tailored, and directed at a legitimate business interest.
Okay. And your experience, you litigate, I know your experience here in Northeast Florida, with respect to enforcement, do those matters go to trial? I presume they would be a bench trial. If so, and how often do they go to trial? And if not, how do you reach a resolution?
Again, it's one of those things that is depends on the context and the circumstances and the scope. It would be nice if they just went to trial with a judge and not a jury. My last two were in front of juries. So, but they were broader than just the non-compete issue. We had wage and hour issues and other things that made it to where, you might very well have to deal with a jury. And then, is the decision making and how the judge allocates what's a question of fact versus law, sometimes things that lawyers like me fight about. But the thing that's different in my experience as a defense employment attorney is that usually an employee is suing us for wage and hour, for discrimination, and we are on the defense. And some of these statutes are very employee friendly. Okay, in the labor employment world, they're very employee friendly statutes. So the challenge with non-compete litigation typically is that we are saying our employee violated a contract and we are initiating the litigation.
Right.
Provisions and things like whether or not attorney's fees are available. Attorney's fees are available only under really two conditions. A statute says so or a contract says so.
Right.
So you want to think about that strategically when you're putting together your contract, clearly. But in reality, if you have an employee that's been working for you for a short period of time, takes some valuable information and runs away with it, and you initiate a lawsuit against them, to what extent are they going to be able to cover not just their attorney's fees, but yours because you have a contractual provision? So even if you win, you're usually in a situation where you're in debt to your attorney, even though you have a contract that said the employee will cover it, because they are judgment proof is the term we use. They're not typically able to meet those types of fiscal challenges on attorney's fees. So
Right.
the way you attack a contract issue is different than defending other types of employment claims from an economic perspective, and that is part of the cost benefit risk analysis for whether or not we should go forward. I'll tell you very few cases, which addresses directly your initial question. Very few cases go all the way to trial. Lawyers usually understand all of these parameters, can make arguments, and can move people together and solve them. And I had heard at one time like 5 to 7% of the trials, of the issues are actually litigated in a trial format. Most of them are initiated, and then somewhere along the way, we have a mediation or we have some sort of informal negotiation where we help people realize the strengths and the challenges of their position and help them to find compromise.
Mm-hmm. Wow, good stuff, Mark. This half hour has flown by, my friend. Really great information, lots to think about, so many things to protect. And we didn't even get into rating employees, for instance, leaving a company and then trying to bring your friends there with you. So they're just multiple layers of issues. And you know what? We didn't get into separation much either. So, which as
I'm
every
happy to come
business owner,
back.
yeah, well, hey, okay, all right. If that door is open, we'll do it. Every business owner knows that's one of the hardest things is to uh part successfully with employees. I think that I've gotten better over the years. I'm certainly not perfect at that. I have people that have worked for me in the past that I wish the ongoing relationship were better. And then some that I'm really glad that we have no ongoing relationship at all.
Right.
But how important it is to get that agreement, if possible, in writing on the way out, protecting both sides. So lots and lots of issues here. Anybody that hasn't written Mark's name down and doesn't use Google, feel free to pop me an email or my team at questions@rocksolidlaw.com. We'd be delighted to make an introduction to Mark for any of you that don't already know him. I suspect most people viewing this do because Mark just has an excellent reputation in this area of law and in this area of the world as one of our finest. Mark, you know I love you. I really appreciate your time today. What fun to be at a point in one's career where you could spend a half an hour enjoyably talking about law, and hopefully, not hopefully, I absolutely believe we've delivered value this morning to everybody who is listening now and will listen in the future. Again, guys, if you'd like an introduction, let me know. If you need to talk about anything in the areas we serve, just write questions@rocksolidlaw.com. We'd love to get together with you. Any parting thoughts, Mark?
Thank you for the opportunity, first of all, to talk to folks and people. And I love to teach and train and think about these types of things and express it. This is a dynamic area of law. There's a lot going on. So, hopefully that was pretty obvious. You're going to have to really customize a solution and make sure you think it through for it to be really effective. But
Yeah.
sorry we couldn't get to everything, but that'll give me the opportunity to come back and maybe get focused on other aspects of the employment relationship and contracts that deal with those types of things.
Yeah, let's do that later on this year. I can't think of anything I'd rather do. Everybody, thank you so much for joining. I'm going to leave you once again, zooming with the Commodores. I am John Miller, Rocksod Law and Title, joined by Mark Addington this morning. Thanks, everybody.
Thank you.
Great day. Bye-bye.